How's it going, guys? This is Nawson, and let's do another Darrell Brooks video.
All right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
Don't consent to
Today, Junior?
being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
I'm Darrell Brooks, but I'm also not Darrell Brooks, and Darrell Brooks is someone I'm representing as Darrell Brooks. Is that clear as mud, Your Honor?
I'm a dude playing a dude disguised as another dude.
What?
You a dude that don't know what dude he is.
Or are you a dude who has no idea what dude he is and claims to know what dude he is?
What the fuck are you guys talking about?
By playing other dudes.
I know what dude I am.
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
Yes, that's a great idea. Actually, considering that idea, let's just play the whole trial out. And then afterwards, we'll redo the entire trial. Like, we'll print out the record, and we'll all read off the record, like doing like a Shakespearean play in high school.
To be or not to be? That is the question. Whether 'tis nobler in the mind to suffer the slings and arrows of outrageous fortune,
Or to take arms against a sea of troubles, and by opposing in them, to die, to sleep no more.
And we'll just redo the whole thing just to make sure that the record is clear and accurate.
The appearances are as they
I love
were
how she
this
just
morning.
ignored that.
They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court.
I can't find a single clip where he doesn't bring that up. It's such a... Yeah, I'm not even... I'm beating a dead horse by bringing up him beating that dead horse.
Has subject matter jurisdiction. And at this point, may I request, David, that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming
That's unnecessary. It's implicit in that she decided to rule over the case. How ridiculous.
out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
She knows what's coming. She knows what's coming.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will. I will.
Thank you.
Wow, we're so privileged. What a privilege that you shut your mouth for 2 seconds.
Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again.
I wonder if she knew how long this is going to go on.
And for the record, that I do not identify
She couldn't have.
by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
What does that mean? What the heck? I can't even figure out what that's supposed to mean. Do you have the full power of the state, or is that military power? Or is this military? Neither?
I'm sorry? I don't understand what you're asking me, sir.
What?
I'm asking, is
And on what
this,
legal basis are you making
I'm-
that request?
I'm asking for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case.
That's already addressed when she's appointed as judge, that there's no conflict of interest.
And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told
He hasn't been getting nice baby powder for his bum.
by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified.
Oh, I remember that. Oh, I think that's later on. Yeah, it's later on in the trial where he brings that up again. He gave her the oath of office, but it just wasn't signed. That's probably what he's talking about with a lot of this documentation too. It's just not the certified original copy, which there's no reason to provide.
Certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean.
Ah, yes, Darrell's family annihilation defense. If a murderer walks into a home and kills every single member of the family and extended family, well, they got to get away with it because there's no one there to file a claim against the murderer.
Josh! Scott!
A living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet.
Record of a bond in his docking sheet? Is he referring to his like Sovsit theoretical imaginary bank account? I think he is.
I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear.
They're clear because discrepancies is a big word, and I used it. I'm a big boy now.
Mommy, wow, I'm a big kid now.
I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them.
What do you mean by disregarded? I mean, like, how do we regard them? Most of his filings are unregardable. Like, they're not even asking for something to be done.
Which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these.
Whenever he brings up that he doesn't understand the true nature and cause of the charges, I wish like a midget would walk across the desk with a megaphone and just start screaming in his ear, "We think you ran over 68 people and killed 6."
Proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity.
Because I
As
said
we sit
so.
here today, I'm still being charged.
I'm being charged. I'm still being charged.
With charges that shouldn't even exist based on the testimony that we've heard for the last few days.
What? Have we been watching the same trial? How do you draw that conclusion based on the past couple days?
I was positive it was you.
Who is you?
You. I'm looking at you.
There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things. And Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the 3 that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record.
Yeah, see, he's being provided some of this bullshit, and it's all bullshit. But he's being provided copies, so now he's acting like he's not getting them at all. Man, that's so sneaky. I didn't catch that the first time I watched this trial. I actually was thinking he wasn't getting these documents by the way he was phrasing it. He was getting them. He just wasn't getting the original certified copies because they don't give those out.
It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem when I'm merely seeking understanding because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for your honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury.
Yes, because it's not a fair trial unless every document you get is an original certified copy, and the judge arbitrarily just accepts some of the things you say simply because of the volume of them, not having anything to do with the merits of your argument. Just I made 600 arguments. You should accept at least 10 of them. This is biased.
I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim?
Yeah,
I
dig them
asked
up.
your honor numerous times for your honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything. Which you stated for the record a non-responsive answer. A non-responsive answer is an agreement.
Pretty out of context, man. I didn't do anything. Going around to everyone in the court. I didn't do anything, right? I didn't do anything, right? Then that one person that doesn't hear him. Oh, he didn't say anything. I guess I really didn't do anything.
Will be a tactic agreement by you, your honor, that you don't have to answer these questions that you should be answering. I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff?
Ridiculous.
Who's bringing the claim?
Ridiculous.
Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not your honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person.
Not your honor. Why would the judge be an injured party acting as the plaintiff? That makes no sense. That's so stupid. But he actually asked her that.
I have the right to demand that the court place in the evidence any unrevealed contract.
One more time.
I have the right to demand that the court place in the evidence any unrevealed contract.
Any unrevealed contract? He's got to be taking that line out of context. That doesn't make any sense.
Has that been provided to me? Have that been placed in the evidence? I would like to see it, which is my right.
Has what? Which unrevealed contract? Every unrevealed contract in the history of ever? Should Judge Darrell have driven into court in in a friggin' uh, with a flatbed full of documents. Just fill the entire courtroom full of documents.
Has anyone noticed that building there before? What? Oh, Lord. Crimson Permanent Assurance!
I have the right to inform the jury about the truth in their duty, in their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know?
Yeah, we get it. We get it. They deserve to know. We get it.
They ultimately have the power.
Yeah,
They
have the
decide
power. And they're gonna know.
the matter. Why are we keeping
What makes him droll on like that? He just goes on and on, repeating the same thing over and over again.
information, valuable information from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times, only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea.
Yes, because I'm sure he's interested in pleading guilty, right? I'm sure it's not just something to add to his list of grievances to try to get the trial delayed.
That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times.
Oh, yes, you
I
have.
have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. And
That's a self-identification argument, right? That's kind of like the gender pronouns. Like he thinks that if he thinks he's something, you have to confirm his beliefs. If he identifies as a third-party intervener, you can't call him Darrell Brooks. Otherwise, you belong in jail.
Right beforehand, you fucking said, sir. Sir? Okay. Motherfucker, take it outside. If you want to call me sir again, I will show you a fucking sir.
I apologize.
Motherfucker.
I apologize now.
I need your corporate number. Because I'm going to call them and talk about how it was misgendered several times in this store.
I apologize for that.
I need your corporate number now.
For not confirming his self-beliefs.
in fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of
crap.
So much information. I haven't even gone through half of it. It was stated for the record that The discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the...
You wouldn't have gone through it anyway. Fuck you. Can you imagine this piece of crap actually, like, sitting there in his cell and reading all that shit? There's no fucking way.
the digital discovery and things of that nature. How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least. At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew
He's starting to raise his voice. He's getting himself worked up here.
there is no possible way, humanly possible, that I could be ready for a trial of this magnitude.
He's getting worked up talking to himself about nonsense.
In 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment.
You said that.
I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your
You
Honor?
said this.
Do you know if anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted. Based on that alone, there's no injured party in this matter. So who makes the claim? Who?
Me. I make the claim.
I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until the appealing process, but my right is that I can raise that issue during the case, which I've attempted to do.
No, you did. Therefore, your right was fulfilled. You raised the issue. You raised it.
That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning.
So, all set then?
I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention.
Yes, the unfettered First Amendment rights argument. Like, you can just walk in there and be like, blah, 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 blah.
I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity.
It has validity. So nana nana boo boo.
I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time.
You do? You have the right to do that? Says who?
Which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date, way past when the change of venue motion was brought up.
I'm pretty sure that means a speedy trial once it's began. I don't think that means that the trial has to take place like, oh, well, okay, let's clean up all these dead bodies and we'll just, okay, get in the courtroom. Did you do it? No? Okay, go by.
I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident.
Those bastards!
Every single time.
I gotta find a clip of that. I don't live in that area, so I didn't see their political campaign ads, but that's kind of funny. I'll have to find some examples of that.
The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county.
Yeah, we get it.
Your Honor,
we get it.
Stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something.
They were trading saliva. Case closed. It wasn't a fair.
Danger, danger. High voltage. When we touch, when we kiss. When we touch, when we kiss.
That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out from time to time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature, it would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract.
Well, there's all those contracts again that were never revealed. All of them that were ever made throughout history. All right, guys, back it up to the courtroom. Boop. Let's dump all these unrevealed contracts into here.
That's under the Sixth Amendment. Clearly,
He's such an idiot. Yes, any unrevealed contract, but of course he's not specific about what unrevealed contract he needs to see. Because there's no contract that he needs to see. It's just all of them.
there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding the fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted?
Because it was full of shit.
Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this.
So?
But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas.
Peanut?
Yes, I have one right here. It's bulky, but I consider it carry-on.
Peanut.
Oh, I see.
I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed, and how could the plaintiff not be called to the witness stand?
It's almost as if the plaintiff doesn't exist.
That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a detective, Detective Casey, that got on the stand and said on the record that it is an entity, which is not a living, breathing human being.
Ooh, you got him. You smoked him with that.
And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being?
Third time now.
So where's the claim?
And he's repeating himself over and over again too.
The plaintiff in this matter, the state of Wisconsin, be allowed to testify? Would they be allowed to be in the courtroom?
Keep saying it over and over again.
No, they will not, because they don't exist. Therefore, the claim doesn't exist.
Yeah, we get it. We get your argument.
For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor.
Because the oath of office was not the original copy.
Why was I not provided with a certified copy of your oath of office?
Yeah, Mhm.